Hi, welcome to the Second Law class. I hope you're as excited as I am about doing this class. During the first part of this class, we're going to be spending some time familiarizing you with the legal system and some of the players in the legal system. Some of you may have had some of this in other classes, particularly those of you who have taken a bunch of criminal justice classes. So there may be some review in this, but bear with us, we'll move on at some point. So, let's first discuss how science influences the law. When we talk about science, there are many ways in which you might see scientists in the legal system. And I'm going to just mention a few briefly now, sort of broad brush. One place you might see scientists is when, in an actual case itself, you'll often see scientists provide some kind of testimony in certain cases. So they may have expertise that's important to a particular case, and they might be asked to provide their scientific testimony. Sometimes it might be forensic testimony having to do with a DNA match or fingerprint match. Psychologists will often talk about things like dangerousness, perhaps whether or not a confession was coerced, things like that. And so you're talking about that particular case. Another time when you're talking about a particular case is when people file amicus briefs. Now, don't worry about this because we're going to spend a little bit more time on this. But basically, scientists can sometimes try to weigh in on a case by providing an amicus curiae, which is a friend of the court brief. And we're going to talk about this more. But in any case, again, you're talking about a specific case, and scientists are weighing in on that case. Scientists also weigh in not on particular cases, but on policy decisions. So, for example, we hope that some lawmakers care about whether or not the policies that they're about to enact, whether or not they are in fact make sense. And such, they will turn to scientists and ask for some data. Of course, science can't answer all questions. Just to give you a really great example, many years ago, when we decided to, as a country, to raise the drinking age from 18 to 21, that decision was made. I don't know if any of you were around during that time, but that decision was made basically because they thought that 18 to 21-year-olds were not responsible enough to be able to drink and not drive. And they made arguments regarding their decisions based on we want to try to get lower drunk driving, we want to make people safer, those kinds of words were being said. But if you actually looked at the data at that time, what you found was that the sociologists who actually looked at the data found that in terms of looking at the drinking and driving patterns of 18 to 21-year-olds, actually young adults, what they found is that most DUIs were received by people between the ages of 20 to 25. Now, bear in mind, at this time, when they were doing these studies, 18-year-olds were still allowed to drink. And so what the science says, what the data says, were the people that were most dangerous on the road were not 18 to 21, but rather 20 to 25. But if you really think about it, that kind of data, while important, would lead to a really weird policy decision, right? Can you imagine us having some kind of law that says that you can begin drinking at 18, you must stop at 20, and then you can begin at 25? Obviously, that just wouldn't work. So while science can help us, it's not the end-all be-all, because sometimes the data itself doesn't lead to a good policy. But in any event, these are the many different ways that scientists can influence the legal system. So let's turn back to the amicus briefs that I briefly mentioned. Now, amicus curiae literally means friend of the court. And its practice, the practice of courts using these things, it goes back to ancient Rome. And it's been a fixture in American jurisprudence for nearly 2 centuries. What happens in an amicus brief is that an outsider, somebody who's not part of the case, can file a brief with the court as a friend, because they say, we have an opinion, we have some information, we have some legal theory that is relevant to this case, and we think the court should consider this. So an amicus brief then, pretty much anybody can file. If you have an interest in a case for and you want to weigh in for about $1,500 to $2,000, the fee, that's the fee to file, you can file a brief and you can state your reasons for or against a case. Interestingly enough, as you might guess, there are lots of groups that want to file amicus briefs in certain cases. For example, the Affordable Care Act generated 136 amicus briefs in the Supreme Court when the Supreme Court had to decide. Some very high-profile cases just get literally hundreds of amicus briefs. And an amicus brief can actually be kind of expensive because you have to do some research and some digging to write your brief. An average brief can cost anywhere between $25,000 to $50,000 if you want to do the work and the digging and hire people to really put it together. Now, in terms of social sciences and psychology, one of the most famous types of briefs is called a Brandeis brief. A Brandeis brief, this refers to Louis Brandeis, who many years ago filed a brief advocating to the Supreme Court for an Oregon law that would limit the number of hours that women could work in a laundry. At that time, women were working very, very, very long hours. They were trying to create labor laws that would limit the amount of time that women could be in a laundry. And Louis Brandeis filed a brief in which he actually collected data and provided empirical data that demonstrated that working those long hours had negative impacts on the health of those women. So a Brandeis brief is a brief that includes research, data, and science. Okay? So it's a special kind of brief that doesn't rely solely on logic or legal theory. It actually provides data and research. And this is the type of brief that you're likely to see from psychologists when they file briefs. Just to show you, I'd like to show you the briefs that have been filed by the American Psychological Association. So as you might guess, there will be court cases, and the American Psychological Association has information, data, or something that it wants to tell the courts in that case. So let's just go to the website here. And what you're going to see is the American Psychological Association has filed many, 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 many briefs. If you go to this website up here, you can see the amicus briefs by issue. So this is the particular case. I'm not going to click on any of these, but you can get the full text of the amicus briefs. But I just want to show you some of the different kinds of topics that the American Psychological Association has weighed in on. Abortion, affirmative action, animal research, antitrust, battered women, child abuse, child sexual abuse, competency, something you definitely would expect, confidentiality, psychotherapist patient privilege, copyright. I'm not quite sure what the American Psychological Association had to say about copyright, but they certainly weighed in. Criminal defendants' rights to mental health, the death penalty, disability rights, duty to warn and protect. If you can look here, we're scrolling, and we're only up to the E's. Okay, insanity defense, that would be expected. Mentally ill, mentally retarded, rights of. By the way, just FYI, within the legal system, I know that a lot of people have changed the term. We refer to this people with these kinds of disabilities as having intellectual disabilities, and that's a very common term. But if you look in the legal system, the legal world is very slow to change, and so they still refer to mental retardation rather than intellectual disabilities. Just an interesting FYI. As you can see, the list just goes on and on: sexual orientation and discrimination, use of psychological tests, and so forth. So those are the briefs that are filed by the APA. Now, interestingly enough, While these briefs can be useful to the courts, sometimes the courts get so overwhelmed with amicus briefs that they don't really use these briefs in their decision making. So for example, in one study it showed that in any particular year, only 8% of the briefs, it was a total of 628 briefs in that particular year, only 8% of them were cited by the justices in their decisions. So you can file a brief, but the justices can decide to completely ignore your brief. If you make an impression on them, they will probably use some of that information from the brief in their decision making. Just to show you how overwhelmed the justices can be, here was a recent Supreme Court case on abortion. This was a Texas case in which Texas was severely restricting, this is Whole Woman's Health versus Cole. Texas passed some very draconian restrictions on abortion providers in 2013. And according to the suit, that particular decision by Texas would lead to the closing of most abortion clinics in the state. It was Whole Woman's who brought the suit. If you look now, so for example, look at just the briefs in this case. Just give you an example of what the justices are having to deal with. Here is the briefs in support of Whole Women's Health. In other words, to strike down the Texas law. You can see here, these are all individual briefs that were filed that supported Whole Women's Health. As you can imagine, there were probably just as many briefs that supported Texas. So that the jurists, the justices that have to make some of these decisions may or may not look at some of these briefs in making their decision. And it certainly has, some people have suggested that it's gotten out of hand. Okay, so there's one way. Oops. Okay, yes, that's the slide that I want. So let's get to psychology and law. We are going to be talking specifically about psychology and law. And so let's just briefly discuss this. First of all, when we talk about people who study psychology and law, they come from many different disciplines in psychology. They could be social psychologists, developmental psychologists, cognitive psychologists, or clinical psychologists. And all may have an interest in the law. For example, social psychologists might be interested in how stereotyping and prejudice affects decisions in the criminal justice system. Developmental psychologists obviously are interested in children in the law. We're going to talk about children a little bit more later on, but children and how you interview them when you know that they have to go and give testimony in court was a really big deal. Cognitive psychologists might be interested in decision making, how jurors make decisions, how they weigh evidence, and of course clinical psychologists interested in things like competence to stand trial, not guilty by reason of insanity, and etc. And we're certainly going to talk about all of these disciplines at some point or another. Before I go, let me just say one last thing. Some people act like law is some kind of unchanging thing. To give you an example, one of our Supreme Court justices, Clarence Thomas, claims he's a committed originalist. What does that mean? What it means is that he believes the Constitution should be interpreted as the words were understood by the men who wrote it. In other words, he tries to put himself in the head of our founding fathers who wrote the Constitution and literally interpret the Constitution. And so he uses that lens in all the decisions that he makes. And I would argue that that's not a really good way to do things. Because, first of all, our society changes, and there are things that our founding fathers could not have even conceived of and not even considered when they wrote our Constitution. And so I'm not going to be taking an originalist perspective, and in fact I'm going to say that laws do need to change as society changes. So for example, we have had huge changes in community standards over the years since our Constitution was written. For example, how long should someone stay in school in order to do well in society? When our Constitution was framed, Most of the well-educated people in this country had about a grade school education. And if we put ourselves into their heads, a grade school education is sufficient. And we know that standards for education have changed wildly since the framing of the Constitution. Should a woman be allowed to vote? Certainly the Founding Fathers didn't think so, but we now consider that an inalienable right. How should children be treated? In the 14th century, you could do anything with children. And when our Constitution was framed, we didn't have laws protecting children as well. So again, our community standards have changed, and so our laws need to change with them. And what we consider the pursuit of happiness is different today than it was before, when our Constitution was framed. Also, we have more scientific knowledge than our Founding Fathers did. There are things that they wouldn't have even dreamed about when they framed the Constitution. For example, DNA. We know about DNA now, and they didn't. And we just recently had a Supreme Court case about whether someone could patent your DNA. So we basically, we had a woman who had cancer who died, and they were able to retrieve her cancer cells, and they wanted to patent those cells because they were working on a cure. So can you patent someone's DNA? The Supreme Court said no, but certainly there's no guidance in our Constitution with regard to DNA, but there is guidance with respect to privacy. There have also been huge technological changes that alter the way we think about things. For example, your book talks about the advent of cars and how new laws had to be developed to handle this technology. For example, if you hit a pedestrian with a car, do you have to report it to the police? Believe it or not, this case had to go all the way to the Supreme Court because the Constitution gives us the right to avoid self-incrimination. So if you hit somebody and you call the police, are you incriminating yourself? So the Supreme Court had to weigh in and they basically said, no, it's not incriminating yourself. You do in fact have the responsibility. The internet is another great technological example. It's largely unregulated at this point, but probably that will change over time because there are a host of problems that are coming up. So anyways, in conclusion then, we've got a basic sort of overview here. Next time we're going to talk about legal dilemmas and the kinds of dilemmas that we face when we institute laws and institute policies. Thank you.